afternoon. I'm Kevin Johnson, Dean of UC Davis School of Law. I want to thank you all for being here and attending the Edward Barrett Lecture on Constitutional Law. I want to welcome those who are on the webinar format and will be watching virtually. The Barrett Lecture honors our founding dean, Edward Barrett Jr., who died in 2016 at age 98. He's a renowned constitutional law scholar as well as a criminal procedure scholar. As dean, he worked to establish the academic excellence and focus on community and public service that continues at the UC Davis School of Law. The Barrett Lecture is a marquee event of our annual calendar. It's brought some of the nation's best and foremost constitutional law scholars to King Hall. We'll continue that tradition today with Professor Jamal Greene at Columbia Law School. Professor Greene, the white professor of law, teaches courses in constitutional law, comparative constitutional law, the law of the political process. He's written numerous articles and books, chapters on constitutional law and theory. He co-chairs the Oversight Board, an independent body that reviews content moderation decisions on Facebook and Instagram. Professor Greene holds a JD from Yale and an AD from Harvard College. He clerked for the Honorable Guido Calabrese for the U.S. Court of Appeals for the Second Circuit for the Honorable John Paul Stevens in the United States Supreme Court. Professor Greene is the author of the highly acclaimed 2021 book, How Rights Went Wrong: Why Our Obsession with Rights is Tearing America Apart. That's the topic of his lecture today. Now, this lecture kicks off this year's edition of our Racial Justice Speaker Series. Started last year in response to widespread protests against police brutality. The Speaker Series is now a permanent part of the law school's annual calendar. Last year we had experts and faculty from King Hall as well as from around the country analyze systemic racism in relation to the criminal justice system, family law, corporate governments, immigration, hate crimes, and a variety of other topics. Thankfully, we have great legal thinkers like Professor Greene to suggest new ways forward. It's now my pleasure to introduce Professor Jamal Greene.
Thank you, Dean Johnson. Thank you all for coming out to listen to me. I'm going to talk for a bit and then give people a time to ask questions. So as I'm talking, if things occur to you, you should record them mentally. I'm very happy to be here. This is my first first live lecture since before the Troubles began years ago. So it's especially nice to be here in person and be here engaged in academic exchange and in fellowship with other people. I'm going to talk about how both legal decision makers and the American people more generally should think about rights under conditions of radical pluralism. That's essentially what the book is about. It's about a lot of things, but at bottom, it's about how to think about rights under conditions of pluralism. And I might start with the kind of question that law professors often start with when they talk to law students, which are, what are the facts of a legal dispute? What are the relevant pieces of information we want to know when we submit legal disputes to resolution, in particular by courts? And the argument that I'm going to advance is that we tend to spend, and when I say we, I mean Americans, tend to spend too much time thinking about what I'll call interpretive facts, the meaning of the text, the nature of the right at issue, and not enough time talking about what for our purposes I'll call real world facts. What are the government's reasons? What are its purposes? What are its motivations? What's the means and fit? What are the costs of the actions the government is taking in rights terms? What's the benefit the government is trying to accomplish? And I'll give an example to start, and then we can take it from there. And I think the example I'll use is actually one I don't use in the book, which is Citizens United. And I'll use it because it's an example that a lot of you will have some familiarity with, and if you don't, I'll give you a little bit of a flavor for the case. Citizens United is a case in which the Supreme Court invalidates a campaign finance law. The law prevented corporations from using their treasury funds to engage in certain kinds of electioneering speech. So speech promoting a particular candidate in an election. The interpretive facts, these are the bad facts, the ones we should spend less time thinking about. The interpretive facts of Citizens United are things like, and I'm using facts very casually. What is a speech restriction? What tier of scrutiny, you may be familiar with that term, what tier of scrutiny do burdens on speech occupy? Do corporations have speech rights? Those are the kinds of questions that Justice Anthony Kennedy asked in his majority opinion in Citizens United, and their answers led him pretty straight to the conclusion that he reached. This is a speech restriction. Strict scrutiny applies because it's a speech restriction, and corporations do have speech rights. QED, basically, there was more in the case, but that's basically the analysis in the case. How would someone focused on what I've called real world facts have approached a case like Citizens United? Well, first, let's skip past questions like, are there free speech rights involved in Citizens United? Of course there are free speech rights involved in Citizens United. We can concede that legal premise. So what are the real world facts? These are the facts of the conflict between a litigant and the government. On one side of the dispute, you have an ideological nonprofit, Citizens United. They're trying to criticize a candidate in an election whom it views as hostile to its political objectives. This was a movie, they put out a movie about Hillary Clinton called Hillary the Movie, which was not a positive movie about Hillary Clinton. So it makes a movie about her, and instead of putting it in theaters, it distributed it via video on demand in the weeks leading up to the primary elections in 2008 when Hillary Clinton was running for president. That's one side of the coin. On the other side, the government believes that corporations are abusing the corporate form in order to dominate electioneering, drowning out the voices of individual citizens. So they pass a law, the government passes a law that says that corporations who want to engage in certain kinds of electioneering, but not others, within 30 days of a primary election, or 60 days of a general election, may still do so, except that when they do so, they have to do so through a separate political action committee. They just can't use their general treasury funds to do so. So they've got to segregate their receipts from their political spending. I've lingered on the specifics here because viewed through the lens of real world facts, the dispute in Citizens United is not an abstract, stylized dispute between a government that wants to restrict speech and a set of citizens who want to exercise it. The dispute is between a government that is seeking to protect what it understands to be the political rights of its citizens through a quite specific law, and a corporate citizen whose directors think that the law goes too far towards interfering with their freedom of expression. Citizens United is a dispute between parties. That's what the dispute is about. The relevant questions then become, well, is it true that the government is trying, through this law, to protect the rights of its citizens? Is it legitimate for the government to protect the rights of its citizens, the political rights of its citizens, in this particular way? Does this law go too far towards interfering with the free expression of this particular litigant? In answering those questions, what might we care about? What do we want to know? What pieces of information are relevant to that decision? Well, We might care about the evidence that ordinary citizens are unable to participate meaningfully in the political process under the status quo. That's not discussed in Citizens United. In fact, it's waved away as being something that has an obvious answer, the obvious answer being yes, they can participate meaningfully, notwithstanding lots of evidence that they aren't. We might care about the burdens associated with a corporation relying on a political action committee for its political spending, rather than relying on its general treasury funds. Remarkably, amazingly, that is not discussed in Citizens United. The case proceeds as if there was no alternative available to Citizens United to engage in the electioneering that it wanted to. I'm not a corporate scholar. I don't know how burdensome it is. I would like to know that in trying to think through a case like this. We might care about the difference in audience capture between television ads and video on demand. Now, your law students in 2021, you may not actually remember the time when there were these things called television ads, and people had to watch them. Generally, you had to change the channel, you had to watch them when you're watching something. And so people receiving their political information through television ads were considered to be a pretty captive audience. You change the channel, there's another ad on the other channel. Not the same thing. Well, the video on demand is very different. The only people watching Hillary the movie are people who asked to watch Hillary the movie. Is that different than if you're a captive audience? Should we think about this in a different way? Not discussed in Citizens United. We might care about the difference between the speech interests and the benefits derived from the corporate form of a closely held corporation versus those that are publicly traded on stock exchange. Not discussed in Citizens United. We might care about the difference between an ideological corporation like Citizens United, which is created in order to engage in political advocacy, versus a corporation that is created in order to sell things, like General Motors. Not discussed in Citizens United. Those issues are not discussed because the way that Americans think about rights has encouraged us to think that these kinds of rights conflicts are about rather abstract legal interpretive questions. Is money speech? As opposed to being about real world facts and actual disputes between litigants. At the heart of that tendency is what I refer to in the book as rightsism. Rightsism is a disposition to view a rights conflict as a question of what the right is and whom the right protects. The alternative to rightsism is to view rights conflicts as disputes with important values on both sides of the dispute, that therefore require no abstract discrimination between rights, but rather an opportunity to mediate between disparate views on either side. A rightsist, right, someone who engages in rightsism, views a rights conflict as an opportunity to declare what rights the Constitution protects and what rights it does not protect. Rejecting rightsism instead means viewing rights conflicts as a natural outgrowth of our pluralism, as a legitimate values conflict that is in need of mediation, rather than a declaration of who has rights and who does not. There's nothing inherent in the nature of rights conflicts or in the nature of rights conflicts that are submitted to judicial resolution that requires judges to resolve cases using what I refer to as rightsism. In fact, I think the so-called proportionality framework, which is adopted in many other countries, but not in the United States, does a better job of avoiding rightsism than the categoricalism that Americans use. We tend to put rights into categories. This is why common law is so hard. We tend to put rights into categories, and every category has its own little test. So let me say a bit about how I think we got to this place, and then I'll say why I think it's a problem that this is where we find ourselves. We sometimes associate what I call rightsism with the founders. It's not uncommon to hear something like that argument. We tell something like the following story. You can see this story almost explicitly in a number of Supreme Court decisions, especially in recent years. The Bill of Rights sets out a code of rights. This is the story. Bill of Rights sets out a code of rights that are particularly in need of judicial protection. When we get a rights dispute, the task of a judge, of whoever the adjudicator is to figure out which of those rights is engaged, if any. And when those rights are engaged, those rights are protected robustly. The reason they're listed there in the Bill of Rights is because they are meant to be taken out of the political process. And so if you do any kind of balancing, that reintroduces majoritarian politics into the resolution of the rights dispute. That defeats the purpose of listing rights in the Constitution. Now, what I've just described might or might not be an attractive vision of rights adjudication. As I'll get to, I don't think it is. But in any event, it's wrong to associate this vision with the founders of the United States and of the US Constitution. The founders believed very strongly in rights, but they did not believe strongly in judicially enforced individual rights that were absolute or anything close to absolute. What the Bill of Rights protects, what it seeks to protect, is the localized political institutions needed to work out what people's rights would be. What was to be guarded zealously against in the Bill of Rights was federal interference in the right to live in a self-governing community. That community, acting through its local institutions, its local legislatures and councils, its juries in particular, and almost every provision of the Bill of Rights is focused on juries, through its churches, through its family units, through its militia, would determine the metes and bounds of individual rights. And indeed, it would protect them from outsiders, including federal judges, who were understood to be almost paradigmatically the kinds of outsiders against whom rights were directed. Embedded within the Bill of Rights is a social and primarily majoritarian understanding of rights, not the liberal, quasi-libertarian version that Americans too reflexively ascribed to the US founders today. Now, I don't mean to romanticize that vision. Right? There are lots of problems with that way of thinking about rights, especially in the 18th and 19th century. Most prominently, the self-governing communities at the heart of the Bill of Rights were exclusive ones that gave political power only to white men. This obviously won't do if we're talking about rights in a pluralistic society. Many of the people whose rights were in need of protection were not empowered to participate in self-government. Now, to oversimplify, that's what Reconstruction is about. Reconstruction was meant as a solution to this problem, in recognition that even local governments and even local political institutions cannot be trusted with the rights of minorities or the rights of political outsiders. Those amendments empowered judges and empowered the federal government to protect the rights of those people. And it directly forbid excluding at least some of them from local political participation. Right? That's the 15th Amendment, that's certain aspects of the 14th Amendment as well. Now, of course, those of you who have taken a constitutional law course know that the rights that end up being protected under the 14th Amendment in its early years were not the rights of minorities. They continue to be excluded from local politics, especially in the South. Instead, the majestic language of the 14th Amendment succumbs to the demands of powerful economic actors at the height of the Industrial Revolution. That language gets repurposed away from racial exclusion to protect the property, protect the right to pay poverty wages, to resist unionization and collective bargaining, and to stymie health and safety measures for workers and consumers. What Americans call the New Deal settlement, the end of the 1930s, represents an attempt to recover something closer to the animating political moral vision of the 14th Amendment, while at the same time vindicating the progressive era of social and the social welfare project. You defer to legislation, which can be trusted to use their political judgment to pursue an economic and social welfare program, but you don't defer when legislatures are violating specific constitutional prohibitions, when they're acting in ways that are uniquely undeserving of your trust, such as when they are engaged in certain forms of political self-healing, or when they're passing laws that affect discrete and insular minorities. This is Caroline Products footnote 4, which those of you who have taken constitutional law will be familiar with. The paradigmatic violations of constitutional rights under this settlement are Jim Crow, McCarthyism, other forms of overt political exclusion of one's ideological opponents. John Hart Ely's famous book, Democracy and Distrust, further cemented within the minds of constitutional lawyers in the United States the connection between rights and distrust. Right? Judges step in to protect rights when legislatures cannot be trusted. And under the forms of constitutional law that dominated US courts in the middle of the 20th century, those situations were to be determined categorically. Right? You try to figure out what are the situations where we can't trust the political process. Now, that might work just fine if the only rights conflicts that we're talking about are Jim Crow racial segregation and McCarthyism. Right? In those circumstances, aligning rights with distrust makes a lot of sense because the government actors in those instances could not be trusted. But that categorical kind of Manichaean framework becomes deeply problematic when we're talking about other kinds of rights, indeed when we're talking about most kinds of rights. That becomes obvious when you look at the kinds of conflicts that arose in the 1960s and 1970s during an explosion of rights claiming. Sexual and reproductive freedom claims, gender equality claims, affirmative action claims, disparate impact claims, claims in the criminal procedure space, like Miranda rights, or the rights to a government lawyer, or the right to not have exculpatory evidence concealed in a criminal prosecution. Free speech claims that are not about McCarthyism, but are about speech on campus, or about pornography, or obscenity, or that involve provocative forms of activism, like burning your draft card. Government support for religious schools, government exemptions for religious believers, claims of people who are asking for more welfare benefits, or access to government benefits like tenure at a public school, or asking for their driver's license to not be revoked, or asking to not have their gas shut off by the public utility when they haven't paid their bill. For all of these claims, which is it? Is it that we need to trust the government entirely? Like in West Coast Hotel versus Parish, which encapsulates the New Deal settlement of the late 1930s? Or is it that we can't trust the government at all, to be pursuing any kind of legitimate objective, as in Jim Crow or McCarthyism? Well, it's obviously neither of those things. And yet we have persisted with a categorical framework that tries to fit claims into these binaries. Both sides do this. Conservatives have resorted to originalism or other interpretivist arguments as a strategy for getting to the true constitutional rights, so that they can exclude rights to abortion or to same-sex marriage, but can include rights to commercial speech or rights to guns, or lately rights to religious freedom. Liberals have resorted to a variety of theories, typically not originalism, as a way of getting at the true constitutional rights, so that they can include the ones that the conservatives want to exclude and exclude the ones that the conservatives want to include. So everyone is a little bit rightist. Everyone's trying to exclude the rights that they don't like and include the ones they do, and associate that in some way with the Constitution. In this way, constitutional rights polarization aligns with political polarization. And indeed, it does so over many of the same issues. But it does so only indirectly, by translating political debate into debate over what the framers really thought, or over whether strict scrutiny or intermediate scrutiny applies in a particular conflict. Lawyers then get socialized into these modes of thinking. They come to believe that those abstract legalistic questions are what these disputes are about, right? That these abstract legalistic questions get at the legally relevant facts of a rights dispute. This way of thinking about rights leads to at least three serious problems. Problem number one, it decouples the vital link between rights and justice. So in a disparate impact case, instead of asking about real world facts, like what was the government trying to accomplish? What is the magnitude of the disparate impact? What alternatives were available to the government to ameliorate that disparate impact? All of which speak to the justice of the government's actions. Instead of asking those questions, we ask, here's Washington versus Davis, 1976. Is disparate impact the same thing as intentional discrimination? Concluding correctly that it is not the same thing. Well, that means the Constitution has nothing to say about it. End of case. In a case about school funding inequity, instead of asking, why does this inequity exist? What is the government trying to achieve? What is the magnitude of the inequity? Can the inequity be reduced in ways that are consistent with whatever the government is trying to achieve? Real world facts about justice. We instead ask, is there a right to equal public schools? Concluding that any such right would mean that there must also be a right to food, or a right to equal police funding. The court says there must not be such a right. End of case. This is San Antonio versus Rodriguez, 1974. We look at legal categories instead of looking at real world facts, distorting the relationship between rights and the justice that those rights are meant to promote. Again, nothing in the Constitution itself tells us to do one or the other. Problem number two, what I call the rightsist way of thinking about rights prevents us from acknowledging that genuine rights conflicts can coexist, and therefore need to be resolved at retail rather than resolved at wholesale. We see this in the abortion area, where in Roe versus Wade, Justice Blackmun, writing the majority opinion, concludes without analysis that recognizing fetal personhood as something the Constitution sees and can recognize would have to mean that abortion restrictions are always permitted. This is what he says in Roe versus Wade, and therefore rejects the idea that there must be any such thing as fetal personhood under the Constitution. The Roe court's failure to recognize the possibility of any constitutional interest in fetal life had an immediate impact on the anti-abortion movement. In fact, it splits it in two, with the more radical camp vanquishing the more moderate camp within about 2 years of Roe versus Wade being decided. And they're split over exactly this language in Roe versus Wade. That split, which the moral majority eventually takes advantage of politically, made political compromise around abortion nearly impossible, even though intense moral conflicts are exactly what politics, rather than adjudication, is meant to resolve. So the inability to see the possibility, even the possibility, and you can think of your favorite constitutional questions and think of, if you can ever think of a case in which the US Supreme Court has said, well, this is a case involving rights on both sides. It's very rare to see the court even acknowledge it. Problem number 3 is a related problem. The frame of thinking that I've described means that every dispute ends up being a dispute about whether you are in the category of rights holder or in the category of non-rights holder. Are you living in heightened scrutiny land, or are you living in rational basis land? Those of you, again, who've taken constitutional law, and those of you who haven't, you'll see this when you do take it. But you might recall in a California case involving this very university, the Bakke decision, 1978, affirmative action case at the medical school. Justice Powell laments in that case. He writes a separate opinion, very famous opinion. Justice Powell laments that if the dissenters in that case were to win, the dissenters being Brennan and Marshall in particular, that the only people who would be living in rational basis land, meaning the only people whose claims for racial discrimination would receive rational basis review, would be, he says, white Anglo-Saxon Protestants. He says this in the decision. Because everyone else would get to live in heightened scrutiny. Everyone else would get their claims evaluated rigorously, but white Anglo-Saxon Protestants would not. And he said that creates social conflict. But what Justice Powell was modeling is the fact that rightsism leads to rights envy, right, and raises the stakes of constitutional conflict. So in this pandemic, it's about whether there's a right to hold a religious service, or whether there's a right to not wear a mask, or lately whether there's a right to not be vaccinated. That's on one hand. On the other hand, is there no such right? On the other. Only one camp gets to win. Name your favorite constitutional conflict, whether it's voting rights, whether it's issues around conflicts between religious service providers and the rights of LGBTQ people, whether it's affirmative action, a wide variety of free speech related conflicts, similar dynamics can be observed. Our constitutional arguments have come to recreate our political arguments, but they do so while claiming a legal interpretive certainty. They do so while studiously avoiding the language of deliberation, the language of negotiation, the language of mediation that characterizes political conflict in its ideal form. This then means that when political actors discuss these disputes, they recognize that they implicate constitutional rights. That leads to deference to judges to resolve those disputes, and deference to the kind of zero-sum legalisms that judges celebrate as the right way to resolve rights disputes, as what those rights disputes are about. Why negotiate towards a politically mediated outcome if it's going to go to court and get resolved in a zero-sum way that will align with the political tribe of the judge? Might as well step on the gas, right? Maximize what you will get out of a judicial win. I'm going to more or less stop there. It will come, I think, as no surprise that I don't think this is a healthy way to go about resolving constitutional rights conflicts. I want to leave you with two thoughts before turning to questions. One is that the reason our constitutional rights disputes align with our political disputes is not because judges are activists. It's because rights disputes are indisputably political disputes. We can decide to remove judges entirely from rights disputes. I think that's both a bad idea and one that's too late in our political life. We could continue to be rightist, which has the destructive consequences that I've just outlined. Or we can seek a third way, right? One that focuses on real world facts, one that continues to empower judges, but one that seeks to promote humanism, that seeks to promote mutual respect, and to restore some constitutional responsibility to the political process. The second thing I'll leave you with, and this is really essential to how I think about these conflicts, is that the reason we disagree with each other pervasively about constitutional rights is not because some of us are right about the rights that we have and others of us are wrong about the rights that we have, and we just need to figure out who's right and who's wrong. The reason we disagree with each other about constitutional issues is because we're different from one another. And different people have different values, they have different experiences, they have different commitments. And constitutional law has to figure out a way for those people to live together. And so that's the overarching, from my perspective, that's the overarching goal of constitutional adjudication by judges, and I'm trying to get us closer to it. So thank you, and I'll take questions. I'm going to start with a student, if you don't mind.
Do you think that the common law system is at odds with your way of thinking because the judges need to make rules while ruling on the actual real world facts?
So the question is whether the common law system is at odds with my way of thinking. I gather the premise being, there are a couple of premises involved here. One is that you're going to have to rely on precedent. Right? So when I say, this case is not about the difference between strict scrutiny and heightened scrutiny, it's about real world facts. Maybe that's in some tension with the idea that we have a line of precedents that we rely upon. And the second aspect of this is, and this I think is quite important, the US Supreme Court is part of a system in which it is an apex court, sitting on top of a bunch of other courts, all of which have almost all of which have constitutional jurisdiction. So it's got to lay out some rules for how those courts should behave. Otherwise, there'd be chaos. And I think I'd say a couple of things. The one is that I think that the common law, which I'll distinguish from just being about precedent, it's about incremental development of law, is entirely consistent with a much more rigorous focus on the facts of particular disputes. I think the US Supreme Court understands its role to be. I think the Supreme Court understands itself as what is sometimes called a law declaration court, and abstracts away from the facts of particular disputes. And I think Citizens United is just an example of that. Everything I talked about when it comes to Citizens United is consistent with deciding the case in more common law fashion. Now, one might say, and this is what, if you ask Anthony Scalia this question, not today, but 5 years ago, he would say, well, the common law system doesn't work for constitutional law because we've got to give rules to other courts. Now, empirically, that's, if you had to name a court that is closest to the model that I am suggesting, you would say the Supreme Court of Canada, which is a common law system structured in some differences, a very similar style of judicial review, similar to Supreme Court, also has other courts that decide constitutional cases, and there's no chaos. You manage, judges will always, of course, craft certain kinds of rules in order to decide cases. But it's about a frame of mind that you take when you approach the case. And I can say more about this, but it will take some time. The third thing I'll say, and this in some ways is in tension with the second thing I said, is we tolerate a certain degree of variation in how courts decide cases. The US Supreme Court takes 70 cases a year, and its docket has gotten smaller at the same time that the rest of the federal court's dockets have gotten bigger. It tolerates lots and lots of uncertainty, and that's okay. It's a big country. There's a lot of actually uncertain questions. Right? Of course, you can get to a point where the uncertainty should be resolved at some point if it's leading to jurisdiction shopping or if it's leading to people not understanding what their rights are or what their interests are. Right? But I don't think we should necessarily reflexively assume that variety in rights protection from one place to another is always bad. Just as we don't assume that variety in governing arrangements of other sorts are always bad. Right? That's what we say about federalism. That's the beauty of it. Experimentation, and different people do different things differently because life is complicated. Well, life is complicated when it comes to rights also. And so it's okay, I think, to have some variation. But it's an excellent question. I think it's a non-facetious challenge to the thesis. Yes.
Kind of piggybacking a little bit on the common law question, it seems pretty clear that the rightism that you're talking about kind of creates these perverse incentives to, like you said, escalate political questions into the court. However, do you think that under kind of your alternative view of looking at the facts and actually asking these more practical questions, once a ruling is determined, I mean, it already exists right now where people will look for so-called perfect cases to escalate to the Supreme Court. And once you've kind of seen, okay, these are the circumstances that led to this outcome, can we manipulate the facts to recreate them to either challenge what was ruled before or strengthen them again? I wonder if that incentive would still remain even under that new kind of framework.
So I take the question, and there's another. I'm impressed that the questions are so appropriate, but I haven't given you a text. I'm reading in advance of unless you read the book, in which case, bravo. So I take the question to be, if you're worried about manipulation of various kinds by litigants who are trying to get the court to rule in a particular way, is that a serious concern? Would that be a greater concern if courts were less categorical in the way in which they thought about cases? I haven't thought about this very much. I'm going to take a step back and abstract away from the question a little bit to say that I don't understand what I'm arguing in utopian terms, which is to say, it's not as if I think there's some ideal world out there, and that ideal world looks like what I describe in my book, in my writings. And so any objections to that ideal world must be wrong. Right? It's more that I observe certain tendencies in the law. I think there are ways of making those tendencies better. But if they don't make them better, then we should adjust. Right? So sometimes, sometimes I myself said, Canada is sort of the closest to the system that I'm suggesting. To my knowledge, the problem that you're articulating is not a serious problem under the Canadian Supreme Court. Canada is a much smaller country, even though it's physically larger, it's smaller. It's much smaller in terms of population and the variety of disputes that it resolves. So there may be reasons that it's not a fully satisfactory model. But the point is that Canada could be doing things wrong too. Germany could be doing things wrong too. UK could be doing things wrong too. I use all those as examples in the book to say when we see ways in which the court is going about doing things that appear to be destructive or appear to create a mismatch between rights and justice, or seem to be missing important context about cases, then we can look outside of the system. We can engage in acts of reform. Now, so maybe I'll leave it at that, which is to say, I don't have a good reason to predict that would be a serious problem, but if it were, then we try to work on it. Let me go back.
In your proposed third option, where does that shift the balance of power? Does that put that in the hands to really break down the facts of the case as opposed to the rights that you're talking about? Does that shift to the judicial side, or are you trying to put that back in the hands of the people to make those decisions for themselves?
So great. I don't think this question can be answered in the abstract. Right. So one way of characterizing the question is this judge in power? And there's a sense in which it is, insofar as the ideal form of the kind of adjudication that I'm challenging says, well, we're going to make the law more certain to reduce the discretion of downstream decision makers. A more rule-oriented way of thinking about law is going to disempower judges so they can't make it. This is your classic Antonin Scalia case, right? Now, in practice, because the Constitution is not self-interpreting, like the process of figuring out through interpretive facts which rights count and which rights don't count is incredibly judge empowered, right? So instead of the judges are empowered either way, we don't have the kind of Constitution that can take that power away from them. If you could amend it very easily, if it was extremely specific, then maybe we would. But they're empowered either way. And so the question is, are they empowered in ways that support to decide cases for all time, using interpretive arguments that self-consciously abstract away from the particular dispute in front of them? Or are they empowered in ways that actually look at those disputes? And which of those forms of empowerment you find most persuasive might very well depend on your own view about trust of judges versus trust of legislatures or other actors. So all of which is to say that it depends. It depends on what kind of constitution you have. It also, and here, my priors are that rights disputes should be decided by and large through political processes. That judges should have a role to play, but that role is to set boundaries for political argument. And the way in which I think judges can do that most effectively is by talking about rights conflicts in the language and in a way that's continuous with the language in which we talk about rights conflicts in the political process. So that if you're passing a law or if you're advocating for passing a law, you know what kinds of things to argue about because they're the same things that the judges are going to argue about, right? So if I'm passing a public health measure, if I'm passing a gun control law, I'm trying to think about, well, what are the burdens on people who are affected by this law? What is the problem I'm trying to solve? how close am I getting to solving that problem? What alternatives are there that might be less burdensome on the people burdened by these things? But those are the kinds of questions that legislators, advocates, people who are crafting legislation ask themselves. What the framers think about this is not the kind of question that legislatures ask themselves, right? And so that enables a kind of continuity, a kind of dialogue between the political branches and judges. You know how to craft laws because you're talking the same language as the people who do it. And so in that sense, I understand this as being politically empowered, but it does give discretion to judges. It does require judges to make qualitative judgments, right? So in that sense, it does change the way in which judges think about their job, right? So that's the more textured answer I would give to that.
You answered a lot of my question in response to the question.
That's why I answered.
I guess though I'll ask, I want to know where you fall on the age-old debate, was Madison v. Marbury rightfully decided? Because it seems that you're advocating for the court to be taking more of a backseat, like you said, some boundaries in the balls to the legislatures. And, you know, the rights conflicts precedents, or the law conflicts precedents, and interpretive powers given to the court in that decision seem it might conflict to that. So I was wondering your thoughts.
Well, this is a bigger question than I can answer in 5 minutes, but or 30 seconds or whatever I'll give to it. I would say, so I'm not opposed to judicial review. I think judges do have a role to play in setting the bounds of political conflict, but that role should be connected to judgments made about political domination, judgments made about equality, judgments made about what the government's trying to accomplish, because that's also constitutional weight. Rather than sort of abstract, putting those disputes into abstract legal categories. I actually think that that's very close to what Marshall had in mind with Marbury versus Madison, and not very close to what, for example, Anthony Kennedy had in mind with City of Bernie versus Florida. Right. So where judicial review is today, I think is quite different from where judicial review was back then. So that's the short answer of it. I'm happy to talk later about the longer answer.
I have time for one more question.
I hate being first to last question. Anyway, do you feel that there is? I mean, you say that the legislation should be happening to decide a lot of these things that the courts are deciding instead. But do you think that it's kind of a chicken or the egg problem where the courts are deciding these decisions because politics has become such a zero-sum game itself?
There is a chicken and egg problem here, right? So and that's, I think, broader than legislation itself. There is it's baked into the political culture, right? So part of the reason I think courts approach conflicts in rather binary ways is because they're part of the political culture that approaches things in binary ways. I don't think that courts, certainly not courts alone, can change that political culture. So I think that's fair. I do think that courts make things worse, and that they are in a position to make things better, right? So this is not a kind of, again, it's not a utopianism, and it's not a claim that courts are significant drivers of other aspects of the society that lead to polarization or lead to other kinds of problems, but that courts have a role to play. Courts have made things worse. In the book, there's a whole chapter on abortion rights, which is obviously a complex, difficult, sensitive topic. But it draws a comparison between what the German Constitutional Court, the West German Constitutional Court, does with abortion rights in that context, and what happens in the U.S. in parallel. And it's a long, complicated story. But in the 1970s, abortion rights was a more divisive political conflict in West Germany than it was here. And now it's way more controversial here than in West Germany, and there are ways of tying the path that the politics around the issue took to decisions made by courts. Obviously it's not all of it. There are obviously other important differences between West Germany and the United States, right? But there are very specific points at which courts make decisions that affect how political actors understand their role. And so it's not an empirical study. Political scientists talk about what role courts play in moving political conflict all the time. But there is evidence that how we talk about things in courts does affect how we talk about things outside of courts. Think about, again, going back to this university, the diversity direction, right, which dominates thinking about affirmative action across a very wide range of concepts, and just comes out of something that Lewis Powell's clerks decided to suggest to him in 1978 in a court decision. One decision, one person, one law firm. So maybe that's a good way to end, to say you guys have a lot of power.
Thanks very much.